te hei Māori ora kia tātou. Te hei uri, te hei nako kātou. Kātou haha, te rangi e tūnei. Kātou haha, te papa e ohoro nei. Kātou, te mātuku mai rarotonga. Ko ia i ruku hia manawa pauroto. Ko ia i ruku hia manawa pauwaho. Whakatīna kia tīna, te more. I tipu mai hawaiki, e pupu ana hoki, e wāwā ana hoki. Tārewa tū ki te rangi aua kia eke tanuku, kia eke tangaroa. Whāno haramai te toki, haumi e, ui e, tāe ki e. I runga i ngā tīmatanga koro, ko ngā patu e huri nei ki te rungarawa. Ko e ātonu kei te api kei te manaki a tātou, me whakahonore, me whakakrōria ko tōna ngua tapu. Tūake anau i runga i te tihi o mauau ka te tiro ki tua. Nei da ngā puke maunga e pīkau mai ana, arā a o tāne wai nuku, arā a pū whenua. Titiro atu ki te rohe o waka, te waka o tainui. Ko maunga tautari tērā, ko te awa Waikato rere ana ki taupuri maunga, e mihi nei ki tō tātou kingi Māori, a kingi tūheitia, pōta tau te perapero te tuapitu. E noho nei raru i te ahurewa tapu o nā mātua, o nā tūpuna. I runga i te manaakitanga o te kāhui ariki, me ki ake, rire hau, pai marire ki a rātou. Hoki nei ki te wāhi ngaro, rātou ko huri ki tua te kanohi, he hoki nei ki te nuinga o te whānau, e tatari mai nei tui te arai. Anei ko mātou tēnei kei muri, e tangi nei, e mihi nei. Nō reira haere hoki atu a koutou, ki te nuinga o te whānau. Nei rako te mihi ki te kaupapa o te rangi. Ngā mātā waka ko tau mai ki roto i te mōna o tauranga. Ngā rauranga tira, ngā tapuai, nei rā te mihi atu ki a koutou. Mai a ngā terangi a ngāti pūkenga me ngāti rangi nui. Nau mai, hara mai, whakatau mai. Whakatau mai ki roto i te mōna o tauranga. Nei rā ko koutou tēnei e hiki nei te ara i ture. I tēnei huihuinga matua o koutou mo te motu. Nau reire, e huri nei ki a koutou te kai chaki. Elvin, Mackenzie, ngā kānui te mihi atu ki a koutou i tēnei rā. Whanau, ko te mea rangatira, te mārei kura, kānui te mihi atu ki a koe ko tau mai i tēnei pō, ki te whakanui i a mātou. Hari koana te ngākau ko tai mai koe ki roto i te mono o toi. Nei rā kānui te mihi ki a koe i runga i tō tūranga, hei api, hei manaki a tātou, i roto o Aotearoa, i ngā kārangarangatanga, ngā whare kōti o tātou katoa. Nō reira, whakatau mai. Haria mai o kupenga o te kete o te wānanga ki Wainganui a tātou. A roto i ngā koro kia tau i te pō, kei a koe ngā kororo rangatira mō tātou i tēnei pō. Nō reira whakatau mai koe. Whanau ngā apiha o ngā whare kōti, ngā apiha o te ara i ture, kānui te mihi atu ki a koutou ko tau mai i tēnei ahi pō. Nō reira, kia koutou katoa, ko tai mai, ki roto i te whare wānanga o Waikato hui ai, kia whakakotahi o tātou pakaro, ki runga i te kaupapa o te pō. Nō reira, tēnā koutou, tēnā tātou katoa. Nera, kei au te karakia mō tātou hei tīmata. Kia inoi tātou, e tō mātou matua nui o te rangi kia tapu anō tō ingoa. Nei rā mātou ho ponanga e koropiku akana i mua i tu araro i tēnei ahi pō. Tukuna mai tō wairua tapu ki runga i a mātou. Ki runga i tēnei huihuinga e whakahare ki ana, i roto i te whare wānanga o Waikato. Mā wano hei tautoko ngā kai kore o te pō. Kia piripiri hia kei hea te huarahi pai e pai ake mō rātou katoa. Mā tō wairua tapu rātou hei api hi manaki i ngā wā katoa, nei rātou mātou inoi ki a koe, i runga i te matua te tama me te wairua tapu ake, āmine. Kia ora tātou.
Ena mana, ena reo, te mihi te piringa ki a koto. Tina koto, katoa. Kia ora, thank you very much, Matu, for that very warm mihi, and welcome everyone, and thank you for attending this very special event, the inaugural Te Paringa Faculty of Law and Mackenzie Elvin Law Tauranga public lecture. My name's Professor Aotearoa. I'm the Dean of Te Paringa Faculty of Law at the University of Waikato, and a very warm welcome again to everyone here tonight. This inaugural lecture is a particularly important event because it marks the first public celebration of our 30th anniversary this year. So the faculty was founded in 1991, and we're celebrating our 30th birthday in a full calendar of events, starting with this one here tonight in Tauranga. So we were founded in 1991, and now, of course, we are one of this country's leading law schools. And the faculty was founded upon three core principles: biculturalism, professionalism, and the study of law in context. And these three founding principles continue to deeply embed our teaching, our research, and in essence, what we're about as an institution. And since our very beginnings, we've been pushing, looking at ways in which we can push the boundaries of these three core principles of biculturalism, professionalism, and the study of law in context. And to draw upon a very recent example, a couple of weeks ago, earlier this month actually, in Wellington, the New Zealand Council of Legal Education passed a resolution that Te Ao Māori concepts, and particularly tikanga Māori, would need to be taught in core LLB subjects. And although this move's been seen to be fairly radical in some quarters, I mean, this is something our faculty's been doing for 30 or so odd years, and I'm sure we'll continue to push these boundaries for the next 30 years and beyond. I won't take up any more time. I'm very conscious I'm standing between the main event. So I'm sure you'll have a wonderful evening. Thank you so much again for coming tonight. A particular thank you to Justice Susan Glazebrook. Thank you again, Judge, for your time this evening. And of course to our co-host, Mackenzie Elvin Law, for sponsoring this event. It's been an absolute joy and delight working with Mackenzie Elvin Law, and I'm sure we've got a very strong partnership as it is, and I'm sure it will continue to strengthen as time goes on as well. So thank you very much. I'd like to welcome Marcus Wilkins to the stage. He's going to be MC this evening and also a partner at Mackenzie Elvin Law. Thanks, everyone.
Kia ora tātou. Marcus Wilkins, taku ingoa. Kei Mackenzie Elvin Law, hau e mahi anā. Marcus Wilkins is my name. I'm your MC this evening, trying to control the event. I've got a few notes here. So we've spared you the obligatory housekeeping, but I do need to go through a few things. First of all, there's no smoking, which is evident. The thing's called, the extension of your hand called the mobile telephone. If you could please take it out and turn it off. There's nothing more distracting than mobile telephones going off and buzzing. The emergency exits are here, and you assemble in Durham Lane to the rear of the building should there be an emergency, and the bathrooms are out there down the corridor. Just touching on Dean Roy's comments, we're delighted to have an association with the university. I was pleased the Dean described it as a growing partnership. We hope this lecture will be an annual lecture, that's our plan, in association with the Faculty of Law, and there are other things that we're doing in conjunction with the Faculty of Law to support their establishment of teaching in Tauranga Moana, and hopefully some of our people will be guest lecturing, and we'll be running internships and doing other things with the faculty. And this is a journey we've been on since the faculty established a presence here. We think it's important as a firm that we support the academy and the faculty in this town. It's exciting for us. And lectures such as this are important. Our fundamental duty as lawyers is to uphold the rule of law and facilitate the administration of justice. We see this as an important part of our role as lawyers. So the format tonight will be relatively simple. I'll ask my colleague and the senior partner of Mackenzie Elvin, Dr. Fiona Mackenzie, to introduce Justice Glazebrook. There will be an opportunity for questions of Justice Glazebrook when she concludes her lecture remarks. I will moderate those. any conspiracy theorists in the room can expect that their questions will be answered rather shortly. Then we'll close for the evening. So thank you for coming along tonight. Thank you for your support of this lecture. And as I say, we look forward to hearing what Justice Glazebrook's got to say, and look forward to the continuing association with the University of Waikato. Fiona, I'll let you introduce Justice Glazebrook.
Ngā mihi nui, welcome and good evening everyone. Ko Fiona Mackenzie toka wingawa. I am another of the principals at Mackenzie Elvin Law, and in partnership with the University of Waikato, it gives me great pleasure to welcome our inaugural guest lecturer this evening. Her Honour Justice Susan Glazebrook has an MA First Class Honours, an LLB Honours, and a Diploma in Business Finance from the University of Auckland, and is a Doctor of Philosophy from the University of Oxford in French legal history. She has some long established links to our area, most of her primary school years being at Pew Pew's District High School and attending Tauranga Girls College. She then completed the first 2 years of her BA degree at the University of Waikato before moving to Auckland. Justice Glazebrook was appointed to the High Court in June 2000, the Court of Appeal in May 2002, and to the Supreme Court bench in August 2012. Before being appointed to the bench, she was a partner in law firm Simpson Grierson and a member of various commercial boards and government advisory committees. She served as the president of the Inter-Pacific Bar Association in 1998. Since becoming a judge, Justice Glazebrook has served as a member of the Advisory Council of Jurists for the Asia-Pacific Forum of National Human Rights Institutions from 2002 to 2010, and from 2007 to 2012, chaired the Institute of Judicial Studies, the body responsible for judicial education in New Zealand. More recently, in fact earlier this month, she assumed the role of President of the International Association of Women Judges. In 2014, Justice Glazebrook was made a Dame Companion of the New Zealand Order of Merit for services to the judiciary. Nō reira, tēnā koutou, tēnā koutou, tēnā koutou katoa. Justice Glazebrook.
Try and switch myself on. Is that switched on? It is? There we go. Shall I get rid of that? Okay, and how do I get that to click on? Okay.
And then you push the mouse.
Just push.
Yep.
Great. Tēnā koutou katoa. Nā mihi nunui ki te mana whenua o te roe nei. E nā mana, e nā rangatira, e nā reo. Tēnā koutou, tēnā koutou, tēnā tātou katoa. Thank you very much for the kind introduction, and I'm very honoured to be giving this address. The question that I pose in my title is whether the rule of law is a guiding principle or a mere catchphrase. For the United Nations, at least, the answer appears to be not just a guiding principle, but the guiding principle. The United Nations website says that the rule of law is the foundation of friendly and equitable relations between states and the base of fair societies. It is fundamental to international peace and security and political stability, to economic and social progress and development, and to protect people's rights and fundamental freedoms. As you can see, an all-embracing concept. In his 2004 book on the rule of law, Professor Brian Kamanaha said that despite all the divisions in the world, there was worldwide agreement on one point and one point alone, and this was that the rule of law is a good thing. Support for the rule of law had long been orthodox among Western states, he says, but other supportive statements had come from President Putin, various Chinese leaders, Robert Mugabe, President Wahid of Indonesia, the then President of Iran, and a notorious Afghan warlord. Now, it doesn't take terribly much imagination to realise that this disparate group of supporters either have a very different view of the rule of law from that espoused by the United Nations, or it is indeed merely a catchphrase. But even if it's just a catchphrase for some of those people, the fact that they see it as necessary to profess allegiance to the concept is significant in itself. If it is a different view of the rule of law, the differences are no doubt reflected in the academic debate as to whether the concept of the rule of law should be formal, or as they call it, thin, or alternatively substantive or thick. The thin notions of the rule of law include requirements such as the manner in which laws are promulgated, whether they are clear, that no one is above the law, and requirements that laws not be retrospective. Proponents of the thin view, however, don't pass judgment on the content of the laws. The thick or substantive views of the rule of law include all the thin formal requirements, but engrafted onto the concept are other requirements such as democracy, human rights, and access to justice. So into which camp do I fall, thick or thin? To answer that question, first a bit of history, and I start with the United States, which prides itself on being the oldest democracy in the world and the land of freedom. So looking first at freedom, Isabel Wilkinson, in her recent book, Caste, points out that for the first 246 years of what is now the United States, the vast majority of African Americans who lived in the United States were slaves, who, as she puts it, lived under the terror of people who had by law, absolute power over their bodies, and who faced no sanction for any atrocities they could and did conjure up. And of the 4.4 million African Americans in the United States in 1860, 4 million were slaves. So if you were African American in 1860 in America, there was almost a 90% chance you were a slave, and therefore legally cast not as human, but as property. Wilkinson points out that it took a civil war, the deaths of 750,000 soldiers and civilians, the assassination of a president, and the passage of the 13th Amendment in 1865 to bring the institution of slavery in the United States to an end. Or was it, in fact, at an end? After an all too brief period of 12 years known as Reconstruction, the federal government withdrew from the South and left the liberated slaves in the hands of those people who had enslaved them. And as Wilkinson said, these people designed a labyrinth of laws to put black citizens into indentured servitude, to take voting rights away, to control where they lived and how they travelled, and to seize their children for labour purposes. These laws became known from the 1880s as Jim Crow laws, after a character devised in the 1830s by Thomas Dartmouth Rice, supposedly modelled on a slave and depicted in this next slide. So as Jim Crow, Rice performed a very popular song and dance routine in blackface, acting like a buffoon and speaking with an exaggerated and distorted imitation of African American vernacular English. This was an early example of what were known as minstrel shows, popular from about the 1830s to the early 1900s, where white entertainers in blackface performed song and dance routines designed to mock black people and to perpetuate damaging racial stereotypes. The Jim Crow laws spread throughout the South and even to a degree in the North and basically legalised racial segregation. They were backed up by extreme violence against African Americans by individuals and organisations such as the Ku Klux Klan. Now, while that violence was not legal, it may as well have been, as the perpetrators often operated with impunity and often to large crowds of onlookers and souvenir hunters. A very different fate from the impunity of the Ku Klux Klan awaited any black person accused of any crime, whether rightly or wrongly, even if they avoided lynching. Acquittals were rare, and prison provided yet another form of forced labour. And the courts were complicit right to the top. The segregation laws were given the seal of approval in 1896 by the notorious US Supreme Court decision of Plessy and Ferguson, which concerned a Louisiana law segregating carriages on railways. The Supreme Court upheld the constitutionality of racial segregation under the separate but equal doctrine. There was a minority voice, but a lone one, and ironically from a former slaveholder from Kentucky who had actually opposed the abolition of slavery. Justice John Marshall Harlan famously wrote in his dissent, "Our Constitution is colourblind," and that the arbitrary separation of citizens on the basis of race while they're on a public highway is a badge of servitude wholly inconsistent with the civil freedom and the equality before the law established by the Constitution. It cannot be justified upon any legal grounds. Self-evident, I would have thought. The majority decision to the contrary, however, ensured the survival and expansion of the segregation Jim Crow laws. And it appears that the extent of those laws in the land of the free astonished even the Nazi policymakers who were in the 1930s helping design the laws to subjugate the Jewish people, using the United States laws as their model. Wilkinson points out, no doubt somewhat for rhetorical effect, that even for the Nazis, some of the American laws went too far. She notes that the rule where one drop of African American blood meant classification as black was considered far too harsh for the Nazis to emulate. And it's important to remember, I think, that these Jim Crow laws were not just a temporary aberration. They remained in place for some 100 years, mostly disappearing only as a result of the civil rights movement after World War II. Their dismantling has not, however, meant equality, and some of the restrictive laws have more recently surfaced in another form. Now, because of the importance of democracy and some conceptions of the rule of law, I take voting rights as an example. As I said earlier, the United States is classified as the oldest democracy in the world. According to the World Economic Forum, it clocked up some 219 years as of 2019. Democracies have to be continuous in order to count, by the way, so that rules out France, which otherwise would have had a good claim. Contenders also have to be nation states, and this rules out Iceland, which despite a 1,000-year tradition of parliamentary democracy, only became independent from Denmark in 1944. The definition of democracy for the purposes of the league table requires an executive directly or indirectly elected in popular elections. It requires the legislature to be chosen in free and fair elections, and it requires a majority of adult men to have the right to vote, note men only. So if universal suffrage were required, New Zealand, currently third, would jump to the top of the list, because the United States only granted the vote to women in 1920. But let's have a look, a closer look at the US claim to continuous democracy, even disregarding the lack of women's suffrage. For a start, slaves, not being human, couldn't vote. although given the relative population numbers, the US could still claim that a majority of men could vote. The passage of the 15th Amendment in 1870 did guarantee the right to vote to men of all races, including former slaves. And in the 1880 United States presidential election, a majority of eligible African American voters cast a ballot in every single southern state except for 2. In 8 southern states, black turnout was equal to or greater than white turnout. At the end of the Reconstruction era, remember just 12 years, southern states began implementing policies to suppress black voters, and this led to a dramatic reduction in black voting. One of the main ways of disenfranchising voters was poll taxes, so that required eligible voters to pay a fee before they could cast a ballot. Another was literary tests. Needless to say, these measures were designed largely to affect black voters, and the laws were only finally outlawed with the Voting Rights Act in 1965. And indeed, the poster on the slide was from Texas in the early 1960s. But is there truly voter equality in the United States even now? A 2018 statutory report of the US Commission on Civil Rights, which is an independent bipartisan agency established by Congress in 1957, would suggest not. The report concluded that in states across the country, there are voting procedures that wrongly prevent some citizens from voting, including but not limited to voter identification laws, proof of citizenship measures, and polling places moves or closings. And the report said, no surprise, these measures have a disparate impact on voters of colour and poor citizens. Some of their commissioners in a statement annexed to the report put it as follows: voting discrimination has merely assumed seemingly benign, modern forms, enacted often with discriminatory intent in the guise of election integrity, just as was happening before the passage of the Voting Rights Act over 50 years ago. Now voting rights are under threat again in the United States. Various laws have been introduced by Republican-dominated state legislatures since the last election, purportedly to deal with voter fraud, despite it being absolutely clear that voter fraud is in fact very rare. One of the more extreme of these measures is the provision in Georgia prohibiting any individual other than a worker at a polling place from handing out water within 150 feet of a polling place or within 25 feet of the line of people waiting to vote. This is purportedly designed to ban soliciting for votes, but the consensus seems to be that the provision is not so limited. Further, long queues to vote are the norm largely only in black and poor neighbourhoods. Commentators also point out that the then President Donald Trump had in fact made the discriminatory intent of voter restriction laws very clear when he dismissed a Democrat-led push for vote by mail, same-day registration and early voting, which had been proposed in order to keep voters safe during the COVID-19 pandemic. He said, the things they had in there were crazy. They had levels of voting that if you'd ever agreed to it, you'd never have had a Republican elected in this country again. And then there is gerrymandering, but no time to go into that in any detail. The name was coined in reaction to an 1812 bill redrawing the Massachusetts State Senate election districts to benefit a particular party. This had been signed off by Governor Elbridge Gerry, later Vice President of the United States, and unfortunately for him, in fact, he personally disapproved of the practice. One of the contorted districts in the Boston area was said to resemble a salamander, and on the slides a political cartoon depicting, as you can see, a dragon-like animal that supposedly resembled the very oddly shaped district and which was instrumental in making the term gerrymander stick. But before we get too complacent, let's look at New Zealand's historical record of unjust laws. New Zealand had a poll tax too. This was not designed to suppress voting, but to restrict Chinese immigration. It was passed in 1881, pandering to anti-Chinese sentiment and following the lead of Australia and Canada. The cartoon shows Chinese men leaping over a wall marked New Zealand, aided by a pole marked £100 poll tax. Behind them are many more Chinese, and they're watched in absolute horror by Premier Richard Seddon and by Joseph Ward, who became Premier after Seddon's death in 1906. The cartoon references the view that too many Chinese were still arriving in New Zealand, even with the poll tax. We used literary tests too. From 1907 up to about 1952, all arrivals were required to sit an English reading test as part of a suite of other measures targeted at restricting Chinese immigration. And the poll tax was not repealed formally until 1944, although its use had diminished in the 1920s because other restrictive measures sufficed. It's some consolation that the New Zealand government formally apologised to the Chinese community in 2002 for the injustice of this tax. Turning now to the treatment of Māori, the law again has a lot to answer for, despite the guarantee of equality in Article 3 of the treaty. This gave way in the face of the rapacious hunger for land from the colonisers. First of all, substantial areas of Māori land were confiscated under the New Zealand Settlements Act 1863, including in the Waikato and Tauranga. To make matters even more unfair, land was confiscated not only from tribes who had fought against the government, but also from those who had fought as government allies. But the inroads into Māori land did not stop with the confiscations. The process was continued with the establishment of the Native Land Court in 1852 to investigate titles to Māori land. It was not compulsory for Māori to bring their land before the Native Land Court, but in practice, by 1865, just about all of it had been converted to freehold title. And the result were individual titles that took little or no account of the collective nature of Māori society, and that could be and were readily sold. In traditional Māori society, of course, land is not something that can be owned or traded. Instead, Māori belong to the land. It forms an essential part of their collective identity, with a spiritual link between the land and the people. This slide shows the effects of confiscation and later land policies on land held by Māori. So as shown, from the majority of the North Island being held by Māori in 1860, by 1939, only scattered fragments remained. Māori women, if anything, fared worse than Māori men in the native titles debacle. As explained by the Law Commission, the role of Māori women in society was gradually undermined in the period of colonisation by the colonial view of men as heads of the family, while the role of women of rank as leaders was challenged by the colonial view of the subordinate role of women. The relationship of women with the land was also challenged by the concept of men as property owners. So the Native Land Act 1873 provided that husbands had to be party to all deeds executed by Māori women. Husbands, on the other hand, were free to dispose of their Māori wives' land interest without their wife being a party to the deed. The whakatauki on this next slide illustrates the importance of land to Māori. The translation, as man disappears from sight, the land remains. In Aotearoa, New Zealand, the land may remain, but sadly no longer in the hands of its Māori guardians. And as we know, land alienation had profound effects on Māori society, and in particular Māori women, as it destroyed the collective relationship of the whānau hapu unit to the land, and it thus had serious impacts on Māori social organisation, the effects of which are still being felt today, with serious inequalities in health, education, socioeconomic status, and massive overrepresentation in the criminal justice system. All of which goes to highlight that the law can be a really terrible thing, and to me clearly means that a definition of the rule of law that limits itself to merely formal requirements cannot be supported. The next slide is an illustration of the concept of the rule of law on the website of the Organisation for Security and Cooperation in Europe. That organisation's definition of rule of law encompasses not only formal legal frameworks, but also aims at developing justice systems that guarantee respect for fundamental rights and freedoms in a fair and independent manner. So I thought it provided a good backdrop for this part of the talk. There is, though, a certain irony in justice being depicted as female, given the traditional lack of gender equality in judiciaries around the world, and indeed in society generally. But getting back to the rule of law, in my view, the concept must at least require laws that recognise basic human rights. As Lord Bingham says, a state which savagely represses or persecutes sections of its people cannot, in my view, be regarded as observing the rule of law, even if the laws it uses to achieve its ends are duly enacted and scrupulously observed. Now, it's true that proponents of the formalised or thin concept of the rule of law recognise that the rule of law and those formal requirements is only one of the virtues by which a legal system can be judged. So the thin concept doesn't rule out human rights or other considerations, but says these should be separate from the concept of the rule of law. They argue it would be difficult to achieve a consensus in a more substantive definition, and that compliance would be very difficult to measure. This, in my view, fails to acknowledge the weight of the rhetoric that the rule of law possesses in the public consciousness. Regimes that do not respect and protect fundamental freedoms should not be granted the legitimacy associated with complying with the rule of law by merely formal compliance. As to the contention that it would be difficult to get worldwide consensus on a thick definition of the rule of law, it's true that the rule of law can't be looked at purely in the abstract, and that the content of laws will always depend on the socio-political, constitutional and historical context of a particular jurisdiction. However, the point about human rights, as enshrined in the main human rights covenants, is that they're indivisible and universal. So inclusion of human rights should not, in fact, cause definitional problems except at the margins. Compliance with human rights obligations is, of course, another matter, but all countries, including New Zealand, have issues on that front. Now, there remain a whole lot of academic arguments as to exactly what should be included in the ideal substantive definition of the rule of law. There's not time to go into them, but I do have a soft spot for the very thick conception of the rule of law used by the World Justice Project, probably because I was involved in that project in its early stages. And that definition has 4 principles: accountability under the law, just laws, open government and access to justice. And then under the umbrella of that definition, it has a further 8 factors which are designed to measure adherence to the rule of law throughout the world. And so while one could quibble a bit at the margins as to the inclusions in the index and a bit about the methodology, the fact that the index exists does rather give a lie to the formalists who say a substantive conception of the law would be difficult to measure. I note, incidentally, that the World Justice Project principles don't include democracy, although many of the features they outline are probably more likely to exist in democracies than in other types of regime. Returning now to the concrete as against the theoretical, I'm not going to attempt a comprehensive assessment of Aotearoa New Zealand's adherence to the rule of law. Rather, I concentrate on what might be considered the current underpinnings of the law, as that's an important first step in the analysis. The first point is that New Zealand does not stand alone, and here it is in the centre of the world. Seriously though, New Zealand is part of the world and is subject to international law obligations, including international human rights obligations. Some of these have been incorporated in our New Zealand Bill of Rights Act, so they're directly enforceable in the courts. But even where that's not the case, there's a presumption that legislation will be interpreted consistently with treaties to the extent that the words and purpose of the statute allow. And the courts require, through the principle of legality, any incursions into fundamental rights to be clearly expressed by Parliament. International obligations are also necessarily part of the values, norms and principles to be taken into account when developing the common law. An example of this can be found with the tort of privacy. So the majority in Hosking and Runting recognised a tort of privacy in New Zealand, despite privacy not being included explicitly in our Bill of Rights. So this shows that human rights does form an important part of our current legal framework. New Zealand's law, though, is also necessarily a function of local conditions. So in this regard, I want to return to the theme of the law and its effect on our Indigenous people, concentrating in particular on the position of the treaty and tikanga in our law. The picture shows a modern depiction of the signing of the treaty. I make absolutely no comment on its accuracy, but it makes a suitable backdrop for the next part of the talk. There has been definitely a clear shift in the view of the relevance of the treaty to our law in Aotearoa. When I was at law school, the treaty must have been mentioned, as I was taught legal system by Professor David Williams. But even in the history department, which was my other home, it was seen as something of passing historical interest only. Outside of the university context, the treaty was certainly seen as a focus of protest and rhetoric, but not with any view of it actually having current legal force. Little wonder, as it had been described by Chief Justice Prendergast in Wiparata in 1877 as a simple nullity. Fast forward, though, to 1987 and the Māori Council case, where President Cook said that Section 9 of the State-Owned Enterprises Act, which provides that nothing in the Act permits the Crown to act in a manner that is inconsistent with the principles of the treaty, he said this has the impact of a constitutional guarantee. That the treaty is a constitutional document, at least when given statutory force in that manner, was confirmed by the Supreme Court in 2013. And even where the treaty is not specifically incorporated in legislation, there is a requirement, as with international law, to interpret statutes consistently with the treaty where possible. And of course, the treaty, given its constitutional force, must also be very relevant to the development of the common law. The other major change has been with regard to the position of tikanga. Now, theoretically, tikanga as custom was part of the common law from 1840, but this incorporation was subject to very strict tests, such as a requirement that the custom be certain, reasonable, observed as of right from time immemorial, and not contrary to an Act of Parliament. There was an added requirement for colonies. Custom could not be part of the common law if it was repugnant to justice and morality. And custom would be deemed repugnant if it clashed with the core principles or foundation of the legal system. In other words, in cases of conflict, the superior laws of the imperial power were to prevail. As Professor Peter Fitzpatrick has put it, to the imperial eye, law was preeminent among the gifts of an expansive civilization, one which could extend in its abounding generosity to the entire globe. Looked at another way, he says, the violence of imperialism was legitimised as being exercised through law. And in New Zealand, as we saw with the native titles saga, the imperial law prevailed. Fast forward to the current day, where references to tikanga have started appearing in a range of statutes. In addition, tikanga has been recognised by the Supreme Court as a relevant factor to be considered by an executor in deciding on the burial place of a Māori individual, and without even commenting on the old common law tests for the incorporation of custom, let alone applying them. The majority in the Court of Appeal in that case had gone further and suggested that a process of consultation should be undertaken by an executor, with issues of tikanga being properly explained and explored in the course of that process. The Supreme Court has also recently heard submissions on tikanga with regard to whether the appeal of Peter Ellis against his conviction should proceed despite his death. While the court has not yet issued its reasons for its decision that the appeal should continue, there is force in the view that whatever the place of tikanga and the reasons for that decision, the important point is the fact that submissions were called for, an argument heard on tikanga, even though neither Mr. Ellis nor the victims were Māori. So far, so good. But there remain a number of issues still to be worked out, and I list a few of these without pretending it's a full list. And I'm not to be taken as making any comment on any of them, apart from recognising that they may be issues to resolve in the future. And I also recognise that any resolution of some of the issues may not lie with the courts. First, there's the issue of what Associate Professor Claire Charters calls the Indigenous people's collective rights to authority, and therefore whether it's even appropriate for institutions like the mainstream courts to be delving into tikanga. And this is related to the guarantee made to Māori of unqualified exercise of rangatiratanga or chieftainship over their lands, villages and all their properties and treasures in Article 2 of the treaty, and I'm taking the Māori version and the English translation of the Māori version for that. It also relates to the right to self-determination in Article 3 of the UN Declaration on the Rights of Indigenous People, and that right to self-determination is also included in Article 1 of both of the two main international human rights treaties. The issue is tied up with the concept of legal pluralism, where two or more legal systems exist in the same state. And this in turn raises conflict of law issues and how they should be handled. Second, there's the concern expressed by a number of commentators that incorporation in the common law may end up distorting tikanga and in fact mean not decolonisation of the law, but a recolonisation. And tied up with this is the concern that incorporation could end up stultifying the organic development of tikanga and the necessarily links with the community. Third, there's the issue which arises with the international human rights system generally of working out the proper approach to reconciling collective and individual rights. And this is echoed in cases around the world involving constitutions which recognise both custom, necessarily collective, and human rights, most of which are individualistic or at least have been interpreted that way. And a clear mechanism for balancing individual and collective interests, especially in Indigenous settings, is still a work in progress, both for the international human rights framework and for Aotearoa New Zealand. Fourth, there's the possible distortion of tikanga through the effects of colonisation, and in particular related to the place of women. It's been argued very strongly, however, and in particular I think by Associate Professor Claire Charters, that it should be for wahine Māori to address this in a tikanga appropriate manner rather than the courts, and certainly rather than the framers of the declaration. Finally, there's the issue of how questions of tikanga can be decided in a mainstream court. For a start, it would need a wholly different education and mindset, taking into account sources well removed from the traditional written sources. It would definitely require facility in te reo, language is culture after all. And even then, tikanga would not be a lived experience for non-Māori judges. There's also the danger of such judges seeing superficial parallels between the values and customs of tikanga and the values and rules of the common law and ending up distorting both. It's true there are mechanisms to assist. Where any question of tikanga arises in the High Court, the court may state a case and refer it to the Māori Appellate Court, and that court's decision is binding on the High Court. Another mechanism is for the court to appoint independent expert witnesses or pukenga. I do note, though, hearing evidence on tikanga is treating it as a question of fact rather than law, in the same manner as foreign law is proved in New Zealand courts. So if tikanga is, in fact, directly applicable as law, and that's what we say, this may not be appropriate, although, to be honest, I can't see a viable alternative, especially if the tikanga is contested. So what does all this say about Aotearoa, New Zealand and the rule of law? I'd suggest that until the effects of the unjust laws of colonisation are reversed, the rule of law here can only be considered a work in process. The new place of the treaty and tikanga and the laws of start, and there are of course other initiatives underway to deal with historic disadvantage, including in the courts, but these are beyond the scope of this paper and probably your patience. So as an overall conclusion on the rule of law generally, I finish where I began with my title. So the rule of law is a guiding principle and should be a guiding principle as long as it includes human rights, access to justice, and I would add, redress for historical disadvantage. If that is the case, it's also an appropriate catchphrase, but also catch cry for a better and more just world. Thank you. Yeah, sure.
Well, thank you, Justice Glazebrook. Thick or thin, some of you may have thought that was what you ordered at Subway, but here you are, you've had a real meal of a lecture, particularly for any law students here tonight. Some really thought-provoking comments. Thank you very much. I'm sure that many of you have questions. Tikanga and the treaty, and I was glad that you referenced Small Bingham as well. He's a favourite of mine. So I would invite anyone here who has some questions for Justice Glazebrook to put them to her. She's happy to have those. Andrew.
Thank you for a wonderful lecture. How do you see the rule of law applying to the developments with the worldwide pandemic and the ability of sovereign nations to abrogate their responsibilities to an international?
Has that gone back on? Yes, it has. It's a big question, and I think I was looking probably more at the rule of law in relation to inside nations. The international rule of law is a whole other matter, and I must say that I think it's going to be a scandal of the future, one of those ones where people are going to be saying, what were they thinking? In terms of that inequality that we have between nations, and especially the hoarding, effectively, of vaccines, and not actually providing them to the countries that are going to need them in any sensible manner. So I think in the future, people are going to be looking back and saying, what were they thinking? Especially because with the pandemic, in fact, what they're thinking is very, very dangerous for people who, whether vaccinated or not, who are in the Western world, because these new variants that could be coming from the fact that the virus is running wild in other countries are exceedingly dangerous for everybody around the world. So in fact, self-interest should actually be doing something about those inequalities, even if, in fact, just ordinary moral sense doesn't have that effect. Well, of course, recently Ned Fletcher, in his thesis, has actually said that there wasn't actually a difference in the two versions of the treaty, that in fact the Colonial Office actually did mean to say what it did in the second version of the treaty. It did, in fact, mean to guarantee chieftainship over their sphere to the Māori people, and then it pledged to protect them from the settlers. Of course, by the 1860s, that wasn't happening. So in fact, he would say that there wasn't actually, and I suppose if you're an originalist, so you go back to Justice Scalia, you'd say, well, in fact, you ought to look at that original interpretation, and that should be the proper interpretation of the treaty. I mean, it's interesting, really, because we now seem, though, I think possibly coming from the Maori Council case, to have decided we're not going to look at the text of the treaty. I'm not entirely sure why. We now look at the principles of the treaty, and that seems to be so embedded now, and everybody seems to be talking about principles of the treaty, that possibly all of that, exactly what that means, has become slightly irrelevant. Because I know even the Waitangi Tribunal keeps talking about the principles of the treaty, so it has actually become embedded. People are no longer... And I think that probably comes from the idea that the treaty actually doesn't have force on its own, which is now starting to be challenged a bit, I think.
Thank you for your talk. Within the next 5 years, what do you think will be the biggest challenges to the rule of law in this country?
Well, I suppose I'm fairly optimistic about New Zealand. I think we do have, in the public consciousness, a real view of the rule of law as being important. And I suppose the biggest challenge is really is if we don't do something about the historic disadvantage, in the sense that those people who are at the bottom of the heap remain at the bottom of the heap and don't see any way out, may not actually have that same investment in the rule of law that everyone else does. So that's just why I say decolonisation and the fixing up of historic disadvantage is something that has to happen, because we can't have a law that's not a law for everybody. It has to be a law for everybody, and it has to do something about that historic disadvantage. I guess some of the challenges, but not necessarily to the rule of law, are obviously climate change. And I did an interview recently with Susie Wiles and Helen Clark on COVID-19, and I managed to get them to a point right at the end where there was something vaguely optimistic, and stopped there. But anybody who heard that interview, those seem to be the major challenges of the pandemic, climate change, because they're challenges to the very survival. But nothing so much to do with the rule of law.
Yeah, well, thank you so much. That was really useful and really interesting. I wanted to ask you about, so with human rights and different countries and how they execute those or how they craft them. So with regard to women, so for instance, Iran has just joined the United Nations body for human rights and rights for women. But at the moment there's a film released of Nazreen, the Amnesty International showing here about the human rights lawyer who's been jailed for defending a woman lawyer who defends someone's rights for not working jail. What's your view on how those countries who are on that index, higher up lower on that index, about things like call out human rights, how they're allowed to join those bodies that claim to sorry about the language, I don't know about law.
Well, it's the United Nations system, I guess, more than anything. And there's an issue about the United Nations system and how that operates. I suppose it's something I said at the beginning, though. The fact that those countries actually do want to join those says something about the power of the rhetoric. So one can only hope that because they see that rhetoric as being important, that gradually there'll be change there. It certainly seems to be very gradual. There is a human rights treaty that's been agreed between the Arab states and came into force in 2017. So again, those things take time. If you look at, and just going back to the history, when you look at America, in 1965, it was just getting rid of all of those laws. It's not actually that long ago. And so that gives some hope that at least those other countries might be at the beginning of that stage of changing things. I know it's not a very satisfactory answer, but well, one can only hope, but when you do look at those absolutely appalling laws that were there in the United States, which I think people forget about, and unlike Nazi Germany and Germany, where they actually, I've noticed, especially with the young people, they actually go back and remember those laws and say we can't go there again. That doesn't happen in the United States. They still have that rhetoric of being the land of the free, which is one of the reasons I did the sweep of America. And I mean of us as well, because we think of ourselves as the land of the free, but that hasn't been the case, in fact, for a lot of our population. The formal rule of law says that no one's above the law. That doesn't say you can't have more than one legal system in one country. So you can have two legal systems in one country. Exactly how that would work and when it would work is something that hasn't really been worked through. So what normally happens, of course, with that self-determination is that people have a territory, because that's been the basis of the way one works in the United Nations, is you have nations and territories. Actually, not for that long, but long enough that that's become very embedded. So to have two legal systems in one country is interesting, and I think I think it was mentioned in terms of having those. The tikanga and law, so taught in the universities, is that to mould it into one law together? Is it to have separate laws? And in Canada, in British Columbia, they actually have two different degrees that you can do at the same time. You can do your Indigenous law degree and your other degree, and the idea is you do them both together with a totally different way of thinking and looking in the Indigenous legal system and in the other system. I think we're going the other route. We're saying, well, we'll teach it as part of the core courses, and we'll also teach it separately, and that's what the resolution of whatever the body is that looks after law curricula. So it'll be interesting to see what actually happens, because, I mean, at the moment we have a lot of well-meaning amateurs, I put myself in that category, definitely sort of blundering around in this area. But once we have that base of new law students that are coming, and probably more education of the public as well, in terms of, these are law, and this is law, this is legal system. It's not just sort of something that was back in the ages pre-colonisation. So I think there will be changes. I don't know. I have no idea how they'll play out. Don't pretend to. There'll be lots of controversy on the way and lots of faltering, no doubt. But it's very exciting, and it is quite different, because I was saying to the Chief Justice when I was chatting to her earlier today that I was going to speak about things that were slightly controversial, being the whole American slavery and voting rights, etc. And then I said I was going to talk about tikanga, and oddly, that's no longer controversial. It just seems to be sort of commonplace now. And I find that extraordinary, because really, even sort of 10 years ago, you'd have said something like that and people would have gone, what are you talking about? So it is very interesting, and I think Joe Williams, for instance, has said, well, you know, when did New Zealand suddenly start singing the Māori version of the anthem first? When did that start? Because somebody, I think, was... it's some rugby game, I think somebody sang the Māori anthem and Te Reo and was actually thrown off the field, and now everybody stands up and does it, and it seems just normal. So things are changing.
Thank you very much. In the course of your talk tonight, you mentioned both covenants on human rights covenants. So I am a human rights professor, and so and our own Bill of Rights Act really, I suppose, references civil and political rights, and there's massive gap when it comes to economic, social, and cultural rights, which I think ties into some of the inequalities that you referenced in the course of your talk tonight. So I was just wondering what your thoughts are on how to reset that balance to get more clear recognition of the rights to health and education and work rights.
Yes, it's interesting. I think there's always been a bit of reluctance to bring those before the courts, and I can understand why, because some of those cases haven't gone terribly well for people. I think probably, again, there's a sea change, rather, but you always have that difficulty with that role of the courts and the role of government to a degree. Especially where things that you might decide have to be done are going to cost a lot of money. Now, the Constitutional Court of South Africa and the one, some of the courts in India haven't had a problem with that. And in fact, they've sort of decreed that there'll be water here, and they've actually brought it back to court to say, now is there water there, and have you actually got the portaloos set up? That's one of the South African ones. That's possibly, I think, because of failures of the legislative branch and government there. We don't have that same thing here. And so possibly this resetting has to be at government level and at the politician level and policy level rather than the courts. But I wouldn't rule out the courts actually having a bit of a sea change in respect of those sort of rights. And of course the right to life, which is in our Bill of Rights, has actually been interpreted quite widely offshore to take into account rights to health and climate change and matters of that kind. So I wouldn't rule those out.
I'm really passionate about the rule of law, but one of the things that's sort of concerning me now as I just look at this information is this sort of disconnect around commercial and trading pragmatism and the accessibility to the law, particularly in the imbalance between those who've got powerful wallets versus those who are attempt to sort of preserve some of those religious positions. Obviously, I was interested. You said you were hopeful, so
Yes.
hoping you'll convince me that there is really hope there.
Well, I know our current Chief Justice is exceedingly passionate about access to justice, and I think there are some moves to make things much more accessible. The Rules Committee is undertaking this major exercise to actually split off. I think the idea is that you're actually going to have a level where people can actually get some justice. I'm a bit sceptical of that myself, actually, because I always think those things, they start off appearing as though they're going to be terribly accessible, and then you have to pay $50 to go along. I always tell the story of my mother with her dog lead, where I say that really the consumer laws are basically optional. She had a dog lead that didn't work. Well, if she went to the disputes tribunal, she had to pay, I think, about $40 to go and have it dealt with. Well, I think the lead was $10, so, you know, obviously that wasn't going to be good. I mean, you might lose your $10 as well. So I think there are real issues with access to justice. I know that our current Chief Justice is very passionate about it. In fact, she's got about 3 or 4 overlapping, as far as I can see, committees that are looking to try and get some more diversity. We also have that major initiative in the District Court that the current Chief Judge of the District Court is championing, and I think they should make some difference. Again, one can only be hopeful, but at least people are talking about it, and at least people are realising that the courts just can't be places for people with money, and especially for people with money who are actually trying to do over people without.